afternoon, Judge Tott.
Good afternoon. How are you?
Very well. Good to see you here today.
Thank you.
Welcome, and when you are settled and ready, you may begin with your opening statement.
All right. Thank you, Ms. Roberts. I'd like to just simply begin, of course, by thanking each of you for giving me the opportunity to speak with all of you over the course of the last couple of weeks. It's greatly appreciated to have that opportunity to explain my rationale for why I'm in this type of position, and my background and experience, I think, supports my application. I also want to thank you, obviously, for serving on the commission. I just had the opportunity to serve on a panel in District 3 to choose a new district court administrator. It's a little different scale, but did the same process, reviewing applications, reading letters, and spent all day Wednesday interviewing people, so kind of at the same time as I'm doing this from both sides. But that gave me an appreciation for all the hard work and effort that you put in, so I greatly appreciate what you do. With the time I have today, I want to just try to focus upon how I think I differentiate myself and set myself apart from the other applicants. And I think there's three primary areas that is shown. First of all, I've had the distinct privilege to serve as a judicial officer in the state of Iowa continuously for the last 26 years. And I've had the opportunity during those years to serve in a variety of positions. I served 8 years as a juvenile court judge on a part-time basis in Woodbury County and the surrounding counties. I have also had the opportunity to serve for 15 years in the district associate court system in Woodbury County as a magistrate, and now starting my 6th year, or into my 6th year as a district court judge. So I've had 26 years of experience spread out over basically all the levels of the Iowa court system below the appellate level. And so I believe I have background and experience and understanding of the problems and issues that all levels of our court system face. And we have other judicial applicants, and they're all very good district judges or district associate judges, and Judge May's case, an appellate judge. But they simply don't have the same depth and duration of experience that I would bring to the table. And during my years in the associate district court, not typically, but commonly, I would hear from the district associate judges complaining that the district judges simply don't understand what they do and didn't appreciate the level or lack of support they felt they were receiving from the district court. And I think there's some merit to their contentions. The two systems are different in the volume of cases and how the cases are processed. And so having that knowledge and having been in all of those different levels, and the juvenile court is an entirely separate animal all in of itself. And if you don't practice in juvenile court or have had experience as a judge in juvenile court, I don't think it's possible to even understand necessarily what happens there. But I've been on all those levels, so I can bring all of that perspective to the Supreme Court, primarily for the administrative duties that we have, but also for the adjudicative functions that we do. And I think that clearly the length and the variety of experiences that I've had as a judicial officer sets me apart. And on top of that, I have the experience in Nebraska as well as a mental health referee and with the tribal court system, which I think rounds out that experience. Secondly, during that time and having the opportunity to have those years of judicial experience, I've also had 23 years of experience in private practice representing clients. And that experience was equally as diverse as my judicial experience. I've had the opportunity to serve in large law firms, starting my career in the Eidsmoe firm in Sioux City, which at that point in time, and maybe it still is, the largest firm in western Iowa. Mr. Gray would have to confirm whether it is or isn't anymore, but that's where I started my career. I also spent many years as a solo practitioner working for myself. And I also spent years serving with 2 or 3 other attorneys and firms. So I also understand the challenges that attorneys in private practice faced in dealing with clients, having to, sometimes clients don't have all the money in the world that a corporate client might have, and still having to effectively represent their interests, maybe on a limited budget, and things of that, or just the managing of a firm. But besides that, the type of practice that I have, I believe, distinguishes myself from nearly all of the applicants. We have some very highly qualified attorneys that have applied, that some that are even maybe preeminent in their fields, but their fields are narrow and somewhat limited. My practice has always been basically a general practice of law. I have experience in criminal defense. I have experience in family law, juvenile court, real estate transactions, probate, estate planning, civil litigation, business formations, bankruptcy. And while I may not be preeminent in any of those fields, I'm proficient in all those fields. and have the background and understanding of the law in those areas and can bring that with me to the Supreme Court. The other applicants simply don't have the breadth of experience that I think I bring to the table. The third factor that I think sets me apart is my judicial demeanor and temperament that I've been able to show over the last 26 years. And it's hard for me to stand here and say that without having you appear in front of me to know. So I'm not, in a way, asking you to take my word. But I don't think I necessarily have to ask you to take my word. Because as a district judge, when you have to stand for retention. And before you stand for retention, the Bar Association rates you, and it's published ahead of time before the election. And I'm extremely proud to state that when that was done, when I stood for retention a couple years ago, that I had a 100% retention rate from the attorneys that appeared in front of me. And now you may say, well, you're only a district judge for 1 or 2 years. How does that reflect what your true judicial demeanor are? And if that were the case, I'd agree with you. But I haven't been a judge for 1 or 2 years. I've been a judge consistently for 26 years. And it's the same attorneys that rated me that have appeared in front of me for 26 years. I'd have to believe, if I didn't have the proper judicial temperament and demeanor and didn't treat people with respect and dignity, that there would have been at least one attorney who would have said no to my retention. But there wasn't. I was 100% on that, and I'm very proud of that. And I think it does reflect my judicial demeanor and my judicial temperament. Now, I have to admit, over the course of the last few weeks, as I've been considering this position and the awesome responsibility that comes with this position, there are moments of self-doubt. Are you up for the challenge? It's an awesome responsibility. And in considering that, I had to approach it in the same way I approach every case that comes in front of me. When a case comes in front of me, I decide, first of all, what is the applicable law for the situation? And then you have to determine what facts are relevant to consider those legal principles that I have to decide. And it's the same process I went through with this decision. What are the qualities that make up a good Supreme Court justice? And then compare that with the skills and experience and training and personal intangibles that I have. And after I did that, I came to the conclusion, and this may sound braggadocious, but I concluded that if I don't have those skills, and I'm not up to that challenge, with my experience, who is? And so I've decided that I think I can. And you may be thinking, well, if you had those moments of self-doubt, is that not a weakness, that you wonder if you can do it? On the contrary, I think it's probably my greatest asset and my greatest strength, because I appreciate the awesome responsibility that comes with being a Supreme Court justice. And I understand that no one person knows everything. No one person knows every aspect of the law. You have to be able to work with your other justices. You have to be able to get along with them, to be able to try and build consensus, hopefully build a unanimous decision, but if not, at least consensus. And on those occasions where you can't, you have to be able to agree to disagree and still get along and be professional with your colleagues. I think I bring all of those attributes to the table. And as such, I believe with all of those factors in mind, that I set myself apart from all the other applicants. And I greatly appreciate your consideration of my application, and I humbly ask for your support. And at this point, I would leave any additional time for questions if there are any.
Thank you. And we would like to begin questions this time around with Ms. Stanger.
Thank you, Mrs. Roberts. Good afternoon, Judge.
Good afternoon.
Thank you for your application. Thank you for coming
Thank you.
to visit with us. I really appreciate what you said as far as the awesome responsibility. One of the things I'm hoping you can help this commission with is how we should weigh years of experience in practice or on the bench. I mean, you've shared with us that you have a little bit of the best of both worlds.
Right.
For those applicants that don't have that depth, are there other skills or experiences maybe that provided them the experiences to be on the court? For example, in maybe they served in other branches of government or had other experiences. How should the commissioners weigh that?
Well, I think you have to weigh everybody's entire personal experiences, because there's multiple functions that a Supreme Court justice has to fulfill. You have the obvious adjudicative term where you hear cases and make decisions. but you also have the administrative term where you're dealing with the structure of the court system and how the court system is going to operate going forward. And that entails multiple levels, from staffing to budgets to all those type of things. So I think you have to take into consideration the person's full experience. So if they have experience in budgeting or they've served on governmental committees, I think that's all relevant and should be considered. But at the same time, I think it's very critical that an applicant, in addition to those type of skills, also have prior judicial experience. And especially from the administrative side, if you're making rules and setting up structures and you haven't served in the trenches, so to speak, I don't know that you can have any true appreciation for what your decisions may ultimately truly have on the operation of the local district courts and the lower courts. And so I think there has to obviously be a balancing act, and those factors do play consideration and are legitimate. But at the same time, I think there are other factors that are equally, if not more important.
Thank you.
Thank you. Ms. Pearson?
No question.
Mr. Gray?
Thank you, Ms. Roberts. Judge Tott, one of the things that is occurring up in the 3rd Judicial District is that in order to help spread the workload around, some of the busier courts, clerk courts, for example, are shooting some of the work out to the O'Brien counties and the Ida counties where they want to shift work so we can keep people employed. Do you think that's a good idea?
Absolutely. In the world of EDMS, I think it is a good idea. And EDMS has been, for the most part, a big blessing. It's been a curse in some regards in that there are older judges who didn't like it, and we've lost some judges because of it, but it's made the system much more effective and efficient. And I think you're referring to the rural initiative in the 3rd District, where larger counties or counties that have extra staff can assign duties to that clerk to another county where they may not have necessary staff or complete staff. And in the world of EDMS, that's easy to be done. You simply log in, whether you're sitting in Sioux City or in Ida Grove or Denison or wherever you might be, and you can process the files and the cases and the orders that come through from any county that you're set up to serve in. And in the world of our budget restrictions and seems like every other year furlough situations, I think situations and programs like that are critical. And you never know when the next budget crisis is coming. You never know when the next furloughs are coming. I just simply know that the most frustrating thing that can happen is when I need something and the clerk's office is closed because there's not enough staff. And it has to be equally as frustrating for attorneys with the same problem. And it's a weekly occurrence where the email will come across my screen. The such and such county clerk will be closed from such and such to such and such due to staffing. And it's still today, even when the budget's not bad. So programs like that, I think, are critical to address the shortcomings and which are going to continue into the future.
Thank you.
Mr. Hoytik?
You have a fairly unique application in that Nebraska is often seen as an area in which you practice, and you practice in multiple states. How do you think that would impact, having that perspective impact you as a Supreme Court Justice in Iowa?
Well, my practice in Nebraska would have been a very rural practice. Sioux City obviously is right on the river and borders on Nebraska. When I was born, I was raised in Dakota County, Nebraska. Grew up in a small town of Jackson, 200 people, about 20 minutes west of Sioux City. So from the perspective of dealing with rural court systems and the challenges that are faced by rural courts, and I face that now as a district judge in 3B, 5 of our 6 counties are very rural. But I think that brings additional perspective that a strictly urban attorney or strictly urban judge wouldn't have. But it also gives me some perspective on how different states maybe handle certain types of issues too, and whether that again be administrative or substantive. And you never can have too much information on any issue. So having seen how the courts in Nebraska work, I may be able to bring some of that experience to the administrative functions over here as well.
So when the Hawkeyes play the Cornhuskers, who do you root for?
Oh my goodness. John tells me I can't
you can
answer
plead the
that
fifth?
question.
Okay.
But all I can
Conflict of
say,
interest.
well, all I can say is Little Red sits on my desk. So I apologize to everybody else, but that's diversity.
I thought it'd be Go Blue Jays.
Well, there's Go Blue Jays as well in basketball. But,
Yeah. Thank you. Ms. O'Brien?
Thank you. Judge Tott, you had 2 letters of recommendation from people who are currently in the Iowa legislature.
Mm-hmm.
And it's been very much in the press the last few weeks not these particular legislators, but other legislators bragging, I think is the right word, that with the restructuring of the commission, there will be new judges appointed, new justices appointed to the Supreme Court, and their agenda will be achieved. Would you please comment on whether you think that's appropriate and where you fall in that discussion?
Well, I can't stand strong enough terms. I think that's completely inappropriate. The court is not supposed to be a political body, and it shouldn't matter if there is a Republican or a Democrat in the governor's seat. The job of the court is to call balls and strikes and interpret the Constitution and to be independent from the legislature. However the commission is made up, however the choice is made, it's critical that whoever is given this responsibility to serve on the court, his first oath is to the Constitution and to the law, and to make decisions based solely on that and not upon political influence in either direction. I think I know who the two legislators are that wrote letters on my behalf. I don't believe either of them feel that way. I could be mistaken, but if they are, I do not align myself with that train of thought in any way, shape, or form. I think that's actually somewhat offensive, and it flies in the face of the integrity of the court.
Thank you.
Mr. Horbach.
Thank you. Just a quick follow-up question to that recent question. The political entities that say things like that, I just want them to remember that we're in charge of our bias or not biased, and so they can say whatever they want to. It's what we practice, and we choose to practice as an independent, open-minded commission. So with that being said, one of the things when I was doing the budget for the courts was Sioux City was like at the edge of the earth as far as what the Iowa court system saw. Right. So I think you're the perfect person to ask this question about access. If you talk to 99% of the citizens in Iowa, access includes the word Wi-Fi. Mm-hmm. And access is an hour and a half from Costco. But when it comes to the court system, I have to have a court building in my county. And my question to you is, from your perception, is that more important to the court structure or more important to the court user?
A little bit of both, but I would say probably more so to the court user. And from that perspective, I would go back to my days in the magistrate court and the associate district court. A frustration I saw from the court users, oftentimes they'd come in on a afternoon at 1 o'clock on a traffic ticket, and they'd appear thinking they were going to resolve their situation then and there. When they find out that when they plead not guilty, that, well, we'll see you back here in about 6 weeks, they'd look at you, I thought we were taking care of this today. If you simply have regional court centers and not maintain courthouses in each county, the inconvenience for those type of people is enormous. It's difficult enough to take a time off work and drive the 20 minutes to the courthouse you might have. But if that turns into taking off work and basically taking off all day because you have to drive 2 hours to the nearest court center, that's an entirely different story. So in large complex cases, it probably doesn't matter near as much because you wait a year and a half for your day in court and you go do your trial and you're done. But for the day-to-day users, having access to that court system in a convenient manner is critically important. Now, I know there's pilot programs out there where they're trying to allow people in those type of cases to appear on the computer. Enter your plea of guilty or not guilty to a traffic ticket online, and that may address some of those things. But I still think it's the right of the citizens to have access to their courts and have it as convenient as humanly possible. So I think it's important to have a court presence in all 99 counties, if at all possible. When I serve now as a district court judge, I drive. I'll drive an hour to Orange City. I'll drive an hour and 20 minutes to Denison when it's my term in Crawford County, or an hour to Ida Grove. That's simply part of my job and my responsibility. But it shouldn't be the citizens' responsibility to have to incur that burden. They should have access to their court systems. They're the ones that are paying the taxes. They should have that access.
Thank you.
Mr. Spies, we have 30 seconds left. If you can ask a quick question, we'd love for you to do that.
Well, I've been criticized for talking too fast before. First of all, I want to commend you for having a very high rating from the lawyers who appear before you, you scored 100% retention. That speaks a great deal of you. Are there any justices or judges whose writing style, about which you and I have spoken, to which you aspire or admire?
Well, not necessarily in particular, but I would stress and do every effort to try and make my rulings as concise and understandable as possible, not only for attorneys but for lay people. The most frustrating thing, even as an attorney, was to read a long opinion and wonder at the end of the opinion, what does it really truly mean? And I see the value in going through all the analysis, but sometimes that analysis, I think, is just to show how smart you are. You know, we already know we're smart. We're on the Supreme Court. I think we need to be more concise and more understandable, and that's the type of style I would try to implement.
Thanks.
Thank you. Thank you for that brief question. Judge Tott, we are grateful that you're here today. Thank you for your application, and we wish you well.
Thank you very much, Ms. Roberts. Thank you.